We are live.
Thank you very much. It's Wednesday, the 19th of January at 1:04 p.m. Welcome to the hearing of the House Judiciary Committee. We have 6 bills today. We're going to go slightly out of order. We're waiting for Delegate Hill to arrive, but we do have Delegate Szeliga, who can present House Bill 7. Delegate Szeliga.
Thank you, Mr. Chair. For the record, my name is Delegate Kathy Szeliga, and I'm with you today. I'm sorry we're not in person, but with you today on the Zoom call to present House Bill 7, Reckless and Negligent Driving, Death of Another Must Appear. You've heard this before. I think this is my 3rd year that I've brought this bill to the committee. So for those of you that have been on the committee for 3 years, I'm back. And it's a pretty simple bill. It only adds 2 sentences to Maryland law, but those sentences carry a lot of weight for families looking for closure after a tragic death. Under the current law, an individual who kills a person due to reckless or negligent driving may prepay the fine and avoid court appearances altogether. Although additional strain on our judicial system, that it should be considered on any mandate. Something like this it's a non-factor, negligible effect that way. And the court system, I had checked the testimony. I didn't see it, but in the past I've met with them and they've taken a neutral stand on this bill. On any given year, the number of reckless and negligent driving charges that are associated with the death of another is, just in the low double digits. It's an easy way to hold offenders accountable for the life that they ended without damaging the court system. House Bill 7 will require that offenders appear in court for crimes of a life or death nature, which is the least that we can do for families facing a tremendous sense of loss from the death of a loved one. So as you know, if the death of another is caused in an accident and there's some criminal charge, drunk driving or something else, clearly they have to appear in court. But if it's a reckless driving, what happens is at times the person can just pay the fine, accept the points and not show up at court. So this is a bill that was brought to me by ABATE, the Motorcycle Association in the state of Maryland, and a couple of families that were impacted that, you have an amendment for the title of the bill, but just recognizing the loss that these families have faced when their loved one was riding a motorcycle and, they were killed in an accidental car accident. And they really had hoped to have the opportunity to meet the person in court, but instead, the person who caused the accident had just paid the fine. You have testimony from previous years. They were going to submit it this year. I'm wondering if the technology may have gotten the better of them. Last year, the Judiciary Committee did do something similar for vulnerable people. And so I think this will just expand it slightly and, really, I think allow healing for the family of the person who was killed and for the person who caused the accident. I think it could be a win-win for families on both sides. So with that, I would ask for your favorable vote for House Bill 7, and I'll take any questions that you may have.
Thank you very much. We'll go to Delegate McComas, who is still on mute.
Thank you, Mr. Chair. Delegate Szeliga, it's a great bill. I just wondered, did it ever get out of the House Judiciary Committee last year?
No, it hasn't. And Senator Norman, Wayne Norman, who of course Delegate McComas well, he had introduced this bill before me. And we haven't been able to get it out of Judiciary, but I've met with the chairman. I hope to do that again this year. And after the Judiciary Committee passed a similar bill for vulnerable people, I do believe motorcycle riders are vulnerable as well. And we should, also make sure that they're protected in the same fashion. Thank you for asking.
The other quick question is, Delegate Szeliga, is it just for anyone that is killed in a vehicle accident? Or is
Yes.
it- So it doesn't matter if you're in a car and you're killed, or if you're on a motorcycle, you're walking across the street, or in other words, the operative thing is that you are killed by a vehicle.
Right, the death of another, be they a pedestrian, a
Okay.
bicycle rider. You know, as you know, motorcycle riders are vulnerable, especially to ending, you know, that kind of accident that would not precipitate a drunk driving charge or another charge that will require someone to come to court. So yes, it would be all of them, Delegate McComas.
Okay. And the other quick question is, I have you thought about contacting the folks that do grief counseling? Because you know, I would think that this is really would be helpful for the families that lost their loved ones. And so I think that would be another group that would definitely think this is very important.
Yes, that's a great idea. And I know that Anne Arundel County Courts has a similar program for other offenses. And it's been very, very effective in bringing families together. You know, clearly an accident like that, the person that caused the accident, you know, was not intentionally going out to cause the death of another. And I think, you know, it does in other situations really help parties on both sides.
Thank you, Delegate.
Thank you.
Further questions for Delegate Shalega? Okay, I see physical hands from Delegate Anderson and Delegate Conaway. We'll go with Delegate Anderson. I'll just remind the committee gently, we'd like you to use your electronic raise your hand because it's easier for me to keep track of who has and who hasn't talked. Thanks. Delegate Anderson.
Yeah, I apologize, Mr. Chairman. I had the screen minimized. I couldn't find the hand raise part of it.
I was pointing like this, which I realized meant nothing to you. His window happens to be 3 down from me.
Okay. I guess my question is, and I don't see anything wrong with this bill, with the exception of the fact that maybe the penalty is too low, especially if you're going to add the language where a person contributes to the accident that results in the death of another. The fine is only $1,000, but that's, I guess, for another bill. But my question is, even if the bill were to pass, and I do, you know, a lot of traffic work as well, a person comes to court on the day of the trial, and the state's attorney says, well, if you plead guilty, you get a fine of $1,000. You get a fine of $500. So bottom line is, all the person comes to court, they plead guilty to the charge, and they pay the fine. Is that what you're looking for?
No, really looking for an opportunity for the family of the victim or victims to be able to be in court and see that the person that caused this fatal accident has to be held accountable in the court, and also hopefully precipitate some kind of meeting of the two. You know, I'm sure the families are looking for, and I'm sorry. And so, you know, that's more along the lines. I'm not really at this point interested in increasing the penalty, just making sure that there is a must appear component. And if a judge feels like that would be, it should be waived for some extraordinary reason, I would want judges to be able to have that discretion. I think the chairman and I spoke of that in a case that he had litigated. And so being sure that in extreme situations, if you know, the judge could waive it off. But in most cases, I think it's good for both sides, you know, the victim's family, as well as the person that committed this fatality, to be able to be in court together.
Okay, thank you.
All right, we're going to go with Delegates Conaway, then Shoemaker, then Fisher.
Thank you, Mr. Chairman. I looked for my raise hand button, and I think it was turned off after my second bite yesterday. But anyway, good afternoon, Delegate Shalega.
Good afternoon.
Is the title still going to be reckless and negligent driving?
There is an amendment to name it, and I should have it right here in front of me, Christopher and Sherry and Christian's Law underneath. My amendment changes it from Christopher's to Christian. We had a typo in the title, so it's the same title, but the subtitle would be Sherry and Christian's Law, and in memory of these two motorcycle riders who were the victims, fatal victims of an accident.
So under this bill, technically speaking, a person may not be driving recklessly or negligent, but still come underneath of this bill. Is that right?
Yes, if they're charged with a greater crime, then they must appear. There already is a must appear component for a, criminal, but this is just negligent or reckless driving. In our current law, they are not required to appear. They can prepay, as Delegate Anderson said, $1,000. They can prepay that $1,000 fine and not have to show up in court.
What I'm getting to is if it was just an accident and somebody dies, then the person would still have to show up to court underneath of this bill. Is that right?
That's correct.
Okay, thank you very much.
Thank you.
Delegate Shoemaker.
Thank you, Mr. Chairman. Delegate Shalega, so essentially what this bill is providing for is an avenue for victims' families to come into court and make a victim impact statement, more or less, right? Is that essentially all this bill does?
Yeah, exactly that, Delegate Shoemaker. It's just, a victim's rights bill and, leading to no harm. Obviously, it was an accident. Again, if there was malice or, some kind of illegal property to the accident that caused the death of another, they would have to come to court anyway. So yes, this is a victim's right bill.
Okay, thank you.
Thank you.
Delegate Fisher.
Yeah, thank you, Mr. Chair. It's good to see you, Delegate Shalega.
That's my first hearing, and I miss all of you. I'm sorry we're not together.
Well, we'll see each other next week, so that'll be fun times. So I have a couple questions about this bill. There's still points associated with this type of charge, correct? On someone's license?
Yes.
Right. And just to reiterate for like the public hearing, we have 16-year-olds and over driving in the state of Maryland. So I think my question is, I particularly had a case, and it was a young girl. It was a left turn situation, taking her brother to soccer practice, and an individual on the motorcycle was killed in that case. So your bill would require juveniles as well, those under 18, with, it's definitely a mental hardship, either person on that side, for that juvenile to actually attend that hearing, correct?
Yeah, that's correct. And I think Delegate Fisher, it could be actually even more impactful for that juvenile who could potentially spend a lifetime regretting not being able to see the family and say to them, I'm just so sorry. There was an
Do we
accident.
know that or have that from any juvenile rights organizations, or we just have that anecdotally?
Well, I think it's common sense, to say that. And if it was a hardship, the judge could certainly override that and allow the person to not go to court. But
I think that's my only issue, is that with the exception you were sort of talking about in extreme circumstances or when the judge feels so, what I have learned in this committee, as I'm not a natural parent, I'm an aunt, what I think for a child is very different than all my colleagues' opinions on their children. And I just have a concern about a judge in a certain jurisdiction making that decision that one child is exempt from coming to court in this matter and another child in another jurisdiction in our state it is and is not. So I would just highlight that as a concern.
Yeah, I think we have that on everyday occasions in court with judges. And that's why it's so important that the judges are from the communities that they're adjudicating. And I think that, that makes sense. So I understand your concern, Delegate Fisher, but I don't think youthfulness, would be a reason on its own for the accident, again, that causes the death another, not an injury, but a death is obviously a very serious infraction.
Delegate Eric.
Thank you, Mr. Chair. Good to see you, my seatmate.
Yeah.
Thanks for putting in this bill again. Just to dovetail off of what Delegate Fisher just said, I was sort of thinking over it in my head, and I was in a car accident as a minor. It was not my fault, but it was the fault of another minor who hit me head on. And just thinking about my own daughter, who's going to be getting her learner's permit in less than a year, I would want her to go in and see the family. Right now, if she does something wrong, I ask her to write a letter to whoever she hurt and let them know how sorry she is. So I think it's an opportunity, and I don't know, you're a mother as well. Wouldn't you say it's also an opportunity? And what would you do if it was your child that had killed someone? I think that's a really heavy weight, and they're going to bear it no matter what. But there are things as parents we can do to help them bear it easier. And looking the people in the face who you've hurt is probably the first thing that I would want my child to do.
Yeah, I would agree as a mom and a grandma on both. I think that's important. And I would point to the Anne Arundel County program that does a kind of victim restitution program where they get people together, and it's been so successful. Avoiding situations isn't always the best mental health avenue to take. And so that's, the main reason I keep putting the bill in is because I believe that it not only helps the family of the person that was killed, but the person who did it is clearly sorry. No one would think that, again, if there was malice or drunk driving or some other issue related to this vehicular accident, they would be charged with something greater that they would have to appear. But, this just seems to be a loophole, and it's, the number of people, fortunately, there aren't that many folks that are killed every year in these kind of situations. So, we're talking about, way less than 100 across our entire state every year.
Yeah, I really appreciate you putting this bill again. Hopefully this will be our year.
Thanks.
Delegate McComas.
Thank you, Mr. Chair. I know this is the second bite at the apple, but I just want to provide a little context. If Delegate Szeliga could find out what other states do, regarding this kind of a situation, and it's a must appear, that would be great. The other thing is just, I'm aware of a situation that one of my constituents, their daughter accidentally killed someone. And I think it's weighed on her for years and years and years. And so I think these folks, very religious, very good people, but the point is it has impacted that daughter tremendously. So I want to, if you know someone that this has happened to, you appreciate that they do need to be able to unburden themselves, because it does affect them in the rest of their life if they're not able to move on.
Exactly. And Sherry, whom the law is, partially named after, she was a Harford or Cecil County resident. I think she was a Harford County resident. So yes, and it's her family that's come every year. You may have remembered the last time we actually had real people in committee rooms, that the family came, and one of the people involved in the accident is in a wheelchair still to this day. But, Sherry unfortunately was killed in this accident. So yeah, I think it's a win-win. It's a tough situation. No one ever, ever thinks would want to be involved in a fatality. And clearly, it fortunately doesn't happen that often, but I think we get to a win-win with victims and folks that caused the accident.
Okay, seeing no further questions. Thank you very much, Delegate.
Thank you.
Concludes the testimony for House Bill number 7. And now we will move to House Bill number 92. House Bill 92. Delegate Hill, who is with us now, I think.
I am.
All right, that's great. I think it is in fact just you. House Bill 92. Go ahead.
Okay, the pressure is on. I have 90 seconds. Okay.
You have 2 minutes.
Thank you. Good afternoon, Mr. Chair, Mr. Vice Chair, and it's congratulations to Mr. Vice Chair in his new role. HB 92 amends the statutory forms under the Maryland General Unlimited Power of Attorney Act to include an authorization for an agent to perform the acts necessary, including obtaining personal financial records, and to the extent that is specifically authorized, to transfer or gift a principal's property in order to enable the principal himself to qualify for a federal or other benefit or program. To this purpose, HB 92 also makes changes in the limited statutory form regarding gifts and transfers, and in the creation and funding of specified trusts or accounts related to this granting authority. The bill is in the same posture as last session's HB 870 when it was amended and passed by this committee and by the House 131-0. It is the work product of the Life and Health Planning Committee of the Attorney General's 2020 COVID-19 Access to Justice Task Force. And we worked with the elder law and estates and trust sections of the bar to mitigate risk of exploitation of vulnerable persons while trying to ensure that the legislation provides a principal with the flexibility to assign needed authority without being overly broad with respect to the authority to transfer or gift assets. For many seniors and non-elderly disabled Marylanders, the process of qualifying for, applying for, maintaining Medicaid eligibility and other government benefits is an important and daunting task. And the ability of an appropriately and adequately authorized POA to work with Medicaid navigators and others on the principal's behalf can be critical to that principal qualifying for and receiving the necessary and needed benefits. Thank you, and I urge a favorable report.
We thank you very much. Questions for the delegate, the vice chair for the first time.
Hey, thank you, Mr. Chair. This bill that we already unanimously passed, this is the version that we passed. The
Correct.
Amendments have been adopted. Okay, that's my only
Correct.
question. Thank you.
Thank you.
Very pragmatic first question. All right. Are there any other questions for Delegate Hill? Seeing none, thank you very much. That concludes testimony on
Thank you.
House Bill 92. And now we'll stay in Howard County and go to House Bill 187 to Delegate Terrassa, who has a bill, and there should be, there are several witnesses, 4 witnesses total, including Delegate, 3 witnesses, including Delegate Terrassa. So we'll hear from Delegate Terrassa, and then I believe here we also have, I don't know if Byron McFarland is here, and Margaret Henn, if we could bring them in as well, and we'll just hear from everybody. Delegate Terrassa, you're going to get 2 minutes. Everybody else will get 1 minute, and Delegate Terrassa, take it away.
Wonderful. Thank you so much, Chairman Clippinger and Vice Chair Moon, and members of the Judiciary Committee. Thank you for this opportunity to present this bill, which would eliminate small estate fees, correct a regressive probate fee schedule, and make a series of needed clarifications and technical changes to reduce the administrative burden. For the record, I'm Delegate Jen Terrassa. As some of you may recall, this was introduced last session, but didn't receive a vote. In the interim, we've worked to address some of the concerns. This stems from a recommendation from the AG's committee. Oh, a minute flies by fast. And we believe this will improve access to justice in the probate arena. As you know, probate is the legal process of transferring probate assets to the decedent's heirs, and only those that are solely in the name of the decedent. So it does not apply to a jointly home or a spouse or a bank account that you own jointly with somebody. And these haven't been changed in over 30 years, and I think I might be out of time, but I urge a favorable report and happy to answer questions.
We have a whole nother minute.
Oh, I have a whole nother minute. I thought you said I have 1 minute. Okay, well.
You have 2, everybody else has 1. We can talk about that for a minute.
So the primary focus of this is really to address the fees for small estates valued at $50,000. Under the current fees, the fees for those estates range from $2 to $150, and the probate fees for these small estates generate very little revenue, representing less than 1% of the revenues brought in by the 24 registers of wills collectively statewide. However, these probate fees can be a lot of money for families living in poverty who have just lost a loved one. HB 187 remedies the current regressive fees. fee schedule by eliminating small estate fees and making slight adjustments to some of the other probate fees, including adjusting for inflation after decades without change. Well, there's my alarm. I urge a favorable report.
There we go. All right, now we'll go to Byron McFarland and Margaret Henn. Byron McFarland for a minute, please. Mr. McFarland.
Good afternoon, Mr. Chairman and members of the committee. My name is Byron McFarland. I'm the Register of Wills for Howard County. I want to thank Delegate Terrassa for reintroducing this bill and urge a favorable report. This is the product of years of work with the Bar Association, with the nonprofit world, with judges, with registers, with everyone that we could think of to try to improve access to justice, promote basic fairness, and enhance efficiency in probate in Maryland. As Delegate Terrassa said, these fees haven't changed in 30 years. I'm happy to answer questions either today or another time about the details of the bill, but we've tried to resolve some issues that were raised in subcommittee last year. We feel like we have, hopefully, and I, again, appreciate the time to speak with you today. I think this is absolutely needed, and I really hope that we can move this forward this year. Thank you.
Thank you very much. Margaret Henn, please.
Thank you, Mr. Chair and members of the committee. My name is Margaret Henn. I'm from Maryland Volunteer Lawyers Service, and we provide representation to clients who can't afford an attorney. One of the areas we provide this representation is estate administration cases, and primarily that is to promote housing stability for families who are trying to pass down their house, their most important asset, from one generation to the next. And we found that this is particularly something that has been challenging in communities of color, and that is part of the reason we brought it up in the Attorney General's task force that Delegate Terrassa was mentioning. Just wanted to share quickly a kind of a typical client anecdote that we would see. We had a client who was on the deed to a property with 3 other siblings, 2 of them deceased and 1 of them living. He desperately needed to get repairs to his house. He made only $726 a month in Social Security disability income for himself. And it was going to cost him $723 to open the estate for these 2 siblings who are deceased in order to transfer the house into his name and get these repairs through a state program that he otherwise would have qualified for. So this is just kind of an example of how this issue can impact and hold up our clients. He ultimately ended up walking away and not being able to do it because he just wasn't able to afford those fees to open the estate. So thank you again, and we do support the passage of this bill.
All right, questions now. Delegate Grammer to begin, then Delegate Conaway.
Thank you, Mr. Chair, and thank you to the panel. And Delegate Terrassa, I'm sorry to be the tip of the spear against this bill. I just had some issues with it last year, and I wanted to revisit those. If I recall, we did take a vote, and this bill actually failed due to some concerns. And the main concern I have is not that it strikes the fees on the lower end of the scale, which in the totality of the issue would be negligible. But what you didn't mention is that the bill actually scales the remainder of the fees up pretty significantly towards the middle to the top end of the scale. So what if we were concerned about the fees on the low end of the scale for people who might not be able to afford it, why not just, that was the question we posed last year and we couldn't get an answer to, is why not just strike the fees on the low end of the scale that really wouldn't impact anything and keep the rest of the scale the same? And anybody can comment on that. Delegate Terrassa, you're on mute.
Thank you for the question. First of all, I apologize if there was a vote. If there was a vote in the final hours of the subcommittee, I apologize. I did not know there was one. So I apologize if I told something to the committee that was incorrect. But I will say, though, that this eliminates the fees for folks under 50,000 and reduces the fees for anyone with an estate under 500,000. I think and then under $2.5 million, I'm sorry, under $5 million, it is a very small increase in those fees just to offset the cost so that it will remain. I know there was some concern last year that it was going to raise revenues. This year, we attempted to make it closer to revenue neutral. I know that the fiscal note is not saying that, but the attempt was to make it as close to revenue neutral as we could. But over 5 million, there is an increase. And if it's possible to also have Mr. McFarland answer those, I think he could speak better to those numbers. But we did attempt to listen to that concern in the committee that as drafted last year, it was going to raise revenues.
Mr. McFarland?
Yeah, Delegate Kramer, thank you for the question. That's what we were trying to accomplish, and you are correct that we would be raising fees above. It is estates 500,000 or above. Now for estates between 500,000 and like 2.5 million, the increase isn't that great. It really is those really large estates that are over $5 million where the fee goes from 2,500 to 10,000. We don't really have that many of those estates, but it really, when you think about it, if we are correcting the regressiveness of the fee schedule, at the higher end, it has to go up, fairly significantly. But again, I think we're talking about estates that are, we had an estate in Howard County last year that was $280 million. So the fee on that's going to be 10,000 plus, whatever that is. But I think the only way to, correct the regressiveness of the schedule is to have a fairly large increase on the very, very high end. And the last thing I'll say, and I think this was an issue last year, just to clarify, we're only talking about a probate estate. We're not talking about your gross estate. So, for someone who is married and they own their house jointly with their spouse, anyone who, any kind of asset that has a beneficiary on it, any kind of asset that's jointly held, none of that comes through probate. So for married couples, it's actually very easy to avoid probate entirely, as long as you kind of know what you're doing. So again, I just want to stress that we're just talking about the probate estate, not someone's sort of net worth.
And I understand that. And here's my concern. By the time I retire, you're not going to be able to get a row home for under $500,000. Everybody's going to be, the numbers that we see here in the fiscal note, it shows a clear increase in revenues, but that is not going to be accurate with the way assets are going to scale into the future. And everybody is going to be getting an increase. So my question is, just to avoid the drama and the controversy, would you be willing to make it revenue neutral outside of those cuts at the low end?
If that question is for me, I think the attempt was to make it revenue neutral. And I think Mr. McFarland can tell you the difficulties in getting it to exactly revenue neutral. I was somewhat surprised that the fiscal note had it. I don't have it in front of me, but I think it had it at, I can't remember, 500,000 or whatever it was. But Mr. McFarland can maybe explain the difficulties in getting it in much closer to revenue neutral. But I was attempting not to have a fiscal note on it in terms of increasing the cost to the state. If you look at, for somebody somebody whose estate is worth $1 million, and again, this is somebody who doesn't jointly own it. This is somebody, again, $1 million estate, somebody who doesn't jointly own it, somebody who's done no planning on a $1 million estate. Then you're talking about the difference between $750 and $1,000. So that's just $250 increase. Anyway, we're not talking about huge amount of money on that large of an estate. Again, we're talking about an estate where somebody with that much money doesn't even jointly own a property. Then the consequences are not huge, at least from my perspective. But if Mr. McFarland could talk about the difficulties in getting it to revenue neutral, which was what we attempted to do.
Yeah, so.
Go ahead. No, go ahead.
Yeah, thank you. So unfortunately, the registers, the way that we store information and manage our estates, we don't have, we can't easily sort of pull out estate values from all of our estates. So the only way to find that is to actually look at each estate manually to figure out what the value was. We hope to fix that with a new system in the near future. But so it's sort of time consuming for us to do that. As I have looked at a number of counties on a more granular level, sort of estate by estate what the value is, I actually do think that this will come out to be basically revenue neutral. There are going to be some counties that will lose money, some counties that will gain money. Howard County, for example, will go up slightly. Talbot County will go up slightly. Allegheny County will go down slightly. Somerset County will go down slightly. So it really depends on the value of the estates per county. I will concede, though, you're absolutely right that, I suspect that we're around the same age. When, 30 or 40 or 50 years from now, yeah, absolutely, things are going to be worth a different amount than they are now. And I would suggest maybe more than a once in a generation review by the legislature of these fees. Because you're right. I mean, we'll have more and more as time goes on and we have inflation, estates will get larger, and the fees will be higher. So I don't know if there's any kind of provision that you can put in for, a sunset, or for this to be revisited, a mandate that it be revisited in the future. I'm open to those kinds of options.
Okay, thank you.
Delegate Conaway.
Thank you, Mr. Chairman. My question is in reference to Baltimore City. And I want to know how many estates were opened in Baltimore City last year or year before, whichever information you may have, that were less than the $50,000, and how much revenue was that? And how many estates were open in Baltimore between the 50 and the 500,000, and how much revenue was that?
To answer that question, I don't know the answer to that, but again, Mr. McFarland could speak to
Okay.
how that works. I don't think he,
Yeah. Okay.
I'm assuming he doesn't have the data on that, but I know I don't.
Mr. McFarland, you want to speak on that?
Yeah, thank you, Delegate Conaway. Sorry, I've got a million spreadsheets open.
Okay.
In fiscal 2021, Baltimore City opened almost 3,000 estates total, and 1,855 of them were small estates. So that was about 72% of the estates that were opened there. And the total revenue was it was a little over $100,000.
And between the 50,000 to the 500,000?
See, I don't have the breakdown that specifically. I'm sorry. I'm working on that, but I don't have that specifically.
Well, in your best educated guess, would you say that this move might cause Baltimore City to lose state revenue?
As one jurisdiction, yes. The one thing I'll say, though, is that the registers, to maintain our operations, we pull all of our resources as a state. So all 24 offices combine all of our revenue to pay for salaries, expenses, et cetera.
Sure.
So.
But do you know that I'm a delegate from Baltimore City, and that's where my constituents are?
Sure.
Okay.
Well, I mean, I can say that, Baltimore City residents, because a large percentage of them are small estates, this will have a kind of disproportionately positive impact on the residents there. So it's almost 72% of estates that wouldn't pay a fee anymore, and likely a very small number that would have to pay a larger fee, estates that are over 500,000.
But what's the name of it again? Register of Wills office, is their contribution to the greater pool going to remain the same, or is it going to change based on the numbers?
It's going to, every jurisdiction is going to change. I just can't get, until I go through and I can look at every estate individually, I can't tell you what the exact change for Baltimore City is going to be.
Well, if you could get me that type of information, I would appreciate it. Thank you very much.
Happy to.
Delegate McComas.
I would like to just kind of know if you think it's good that we have people that that have large estates and stay in the state of Maryland. Is that a good idea?
I don't have a problem with it one way or another. I'm not sure.
Well, let me just say that I have heard from experts who study economics, particularly the Maryland Policy Institute that's located in Maryland, Christopher Summons. I talked to him about a year or two ago, and he said, I said, well, what could we do about the tax climate? The first thing he told me was we need to make sure that people are not fleeing from the state of Maryland because of estate taxes. And just, you know, that Maryland is just too expensive. And I was kind of surprised because I wasn't expecting that response. And I guess my concern is that we raise money on the wealthy. The wealthy buy the expensive properties, they pay a lot of taxes. And so we're just good. And a lot of folks, and in fact, I think the governor's even made statements that he's very concerned about a lot of people leaving the state of Maryland because it's a tax hell. And it's hard on them. And so they go for other jurisdictions that have better tax climates. So I just wondered if you feel that this bill is going to help or hurt the situation.
To be clear, this is not an estate fee. This is a probate fee. And I think in the scheme of the estate fee, this is pretty minimal. I'm not sure this will have much of from my perspective, it wouldn't have much of an impact on that, but.
They're going to raise the fee for folks for $10,000 on their probate if they have 5 million, and then they're also going to have, you know, a state tax and federal estate tax. And I mean, the climate right now is very hard for people to figure out what they should do because of a different administration. So I guess what I'm saying is that people are going to go for the sure bet.
Right. I would bear in mind that this is only related to estates for which they don't do planning ahead of time and which are not jointly owned. So this is only people with over $5 million in assets that are not jointly owned and that have not done any estate planning whatsoever. I would suspect that for the most part, rich folks with over $5 million in assets will have done some estate planning. And if they're using this as a reason to leave the state, they will have done enough planning to decided whether to do estate planning or not.
All right. Thank you very much. That appears to be the last question for the panel. We appreciate your time being with us today. And that concludes the testimony on House Bill 187. Thank you again very much. We're now going to go to House Bill 74. This is Delegate Juanita Fisher's legislation. I'm going to get into this and actually see who's set to testify. There are 5 set to testify in favor, 1 set to testify against. So why don't we just call up all of those that are going to be testifying in favor. That is Delegate Fisher, John Breen, Elizabeth Hilliard, Ron Jerichow, and John Giannetti. All right, so it'll be 2 minutes for the sponsor, 1 minute for everyone else. With that, Delegate Fisher, if you'd like to get underway, that would be fine.
Thank you so much, Mr. Chair. Thank you, Chair Clippinger, Vice Chair David Moon. Nice to say that for the first time. And the esteemed members of the hardest and best working committee in Annapolis, the House Judiciary Committee. My name is Delegate Juanita Fisher. I'm proud to be here. First bill of the year, introducing HB 74, formerly known as HB 260, and formerly known before that as HB 1213. All to say, it's been 3 years of hard work, and happy that this committee has continued to support this legislation. Juror enfranchisement is super important to our community. Maryland has led the way with returning felons after their time and probation, getting the right to vote reinstored in our state. This bill is the last piece of full citizenship in allowing individuals to be a part of our jury service, our pools for jury service for civil and criminal trials. This bill has passed this committee. This bill has passed on the House floor. This bill has passed out of JPR, and this bill has passed with bipartisan efforts on the Senate floor. This year, I've reintroduced it, but with the changes made by the Senate last year. Basically, the change is that if you have a pending charge, you wouldn't be part of that pool. I would love your consideration and questions. I don't want to be too long. As I said earlier, this is the 3rd time I have introduced this legislation, and I think it's so important that our state leads on this issue for our democracy. As you know, 80% of inmates in Maryland's prisons are African Americans, which means African Americans are being disenfranchised and being part of the jury selection process. And so that is clear. And I think this bill is going to be restorative justice. It restores our civic engagement, and it allows people to be brought into our society in a full extent once their time and debt to society is served and they are rehabilitated. As I said, our state has led on this. I appreciate your green vote and consideration, and just highlighting the change to the committee that myself and my co-sponsor have introduced the same text that was passed by the Senate last year. Thank you so much for your consideration. Thank you, Mr. Chair.
Thank you. John Breen, please, for a minute. Mr. Breen. We may come back to him. Elizabeth Hilliard, please, for a minute.
Good afternoon. Thank you, Chair, members of the committee. Elizabeth Hilliard. I'm the Assistant Director of the Government Relations Division for the Maryland Office of the Public Defender and also a proud resident of the 43rd District in Baltimore City. I am here to just briefly expand upon Delegate Fisher's call for restorative justice in this matter. I'm going to start by quoting Taylor versus Louisiana, a Supreme Court case that noted, "It is part of the established tradition in the use of juries as instruments of public justice that the jury be a body truly representative of the community. To exclude racial groups from jury service was said to be at war with our basic concepts of a democratic society and a representative government." When we take that constitutional principle, a backbone of our judicial society, in line with the fact that in 2010, of the approximately 19 million Americans with felony convictions, nearly 7 million of those people were Black, despite the fact, which is an estimated 36%, despite the fact that Black people comprise only 13% of the US population, we have to consider jury disenfranchisement based on prior convictions, not only an issue of restoring our felons into society, but a racial justice issue. And for that reason, the Maryland Office of the Public Defender is asking that you issue a favorable report on House Bill 74. Thank you.
Thank you. Judge Jericho.
Thank you, Mr. Chairman. My name is Ron Jericho. I'm a former circuit court judge. I'm testifying on behalf of Maryland Association for Justice. You've heard what this bill does, and I'm glad we've submitted a position paper with some citations in it that will support what I'm saying. The Supreme Court in 1979, the Duren case, said that a criminal defendant has a right to be tried by a jury of the community. Maryland Court of Appeals said the same thing in the Lovell case in 1997, and that you have a right to be represented or have your trial before a cross-section of the community. And that was a case where African-American jurors were routinely excluded from the jury pool. And there's a study I cite in there in the 2003 that although 6% of the adult population had convictions, 30% of those that were excluded from jury were Black men being excluded from jury service. So this is a bill that says to enforce the law as it now stands, to have a jury that's composed of the community members that somebody appears before, and that a 1-year sentence under current law excludes all those people from jury service and for life. And that's just really unfair, not consistent with the law. And this bill would set that table right, because if you're the only people who are excluded are people who are serving a 1-year sentence or on probation for that sentence. So with that, the MAJ requests a favorable committee report.
Thank you. John Giannetti. Who's on mute?
Mr. Chairman, you hear me now?
Go ahead.
Very good. Thank you, Mr. Chairman Klippiger, members of the committee. It's great to see you guys. It's been 20 years since I was serving on that wonderful Judiciary Committee. It's great to be back before you. I admire what you're doing. I wish I was down there with you. Listen, this is House Bill 74. You've passed it twice out of your committee. Didn't receive a lot of Republican votes. The bill is stronger this year because we put in an amendment, or the delegate put in an amendment that was, in the Senate's wisdom, able to address some of the concerns that senators had about people with pending charges. And, you know, when you're coming into a trial and you have pending charges, maybe you look at that trial a little bit differently. I think it makes a lot of sense. It does make sense from a restorative justice perspective that those people who have paid their debt to society, once they finish their sentence, they should be able to be citizens again. And this was an important step in that right direction. When it went to the Senate and it passed through on third reader, this House bill, as amended by the Senate, received votes from 4 Republican senators. So it was bipartisan with Senator Edwards, Hershey, Jennings, and West. So that's a large geographic spread for the entire state. I hope some of the Republicans on the committee can support this bill. I think it's a stronger bill, and I hope that you all pass it, give it a favorable record. Thank you very much.
Thank you very much. John Breen apparently is back. Is he? Mr. Breen? His camera and sound are off. Okay. Going once for John Breen, going twice. All right, we'll take questions for the panel. We'll see what we can do. Delegate Cardin to begin.
Thank you very much, Mr. Chairman. Thank you guys for bringing the bill. Delegate Fisher, it's great. I love this bill. I will support it, of course. Can somebody maybe on your panel just allow us to explore why it is good public policy to not allow people to vote once they're done prison sentence? What was the generation of that, the original generation of that? And why is it that once you're out of prison, why shouldn't you be able to vote? What's the impetus behind keeping it the way it is?
You mean serve on a jury, not vote,
Excuse
right,
me.
Delegate? Okay.
Excuse me. I meant
okay.
serving on a jury. I was the floor leader on the vote, on the right to vote, serving on a jury for the same exact purposes.
I will send that to Mr. Giannetti. He seemed eager, or Mrs. Hillard to answer that.
Well, you know, I'm a graduate of the Maryland Law School, and when I became a student there, I realized that the school itself had an embarrassing history that you just had to adopt and had to understand that it was, you know, one of the landmark educational rulings by the Supreme Court of the United States that would allow Black students to actually attend the University of Maryland. Well, you have to carry that. Even though I had nothing to do with it, you carry that. And the same thing as the state of Maryland, we have an embarrassing past in that in the late 60s, we passed a lot of legislation when the Voting Rights Act was passed by the US Congress to try to maybe disenfranchise some of the people who now had the chance to vote. We would say, well, we're not going to let you vote if you've ever been in jail, or we're not going to let you vote if you're a felon. We're not going to let you serve on juries if you're a felon. And so you can look at the genesis of these bills were in the late 60s. And so it didn't make any sense public policy wise, except for those people that were serving in the legislature and the prevailing winds. And so we have to own that as a state. And, you know, by and large, Maryland was one of the leading states with the voting rights. First, we allowed to have one person who had a felony conviction. Now they were allowed to vote again. And now it doesn't matter the number of felony convictions. And now almost every state in the entire country is up at that standard. And now we're attacking, you know, and trying to go after the right to be in a jury. And these are all civil rights. These are rights mentioned in the Constitution as a right that you have as a citizen that the states can chip away at. And we're trying to restore these things. It's the right thing to do as a society. It's, you know, except, you know, you're supposed to have a jury from the community. But, you know, the old fashioned way we learned was you're supposed to have a jury of your peers. Well, you know, we know about the incarceration rate of African Americans in Maryland. We know it's disproportionate to our population. Well, you have approximately, according to a study that was done in 2019, approximately 1 in 3 Black males in Maryland are ineligible to serve on a jury with the current law. So we have to fix that and let people become members of society again. Let these juries be juries of the peers with Black defendants, if that's who the defendant is at that time.
Thank you.
Let's see if John Breen is back. John Breen?
Speaking.
All right, we'll hear from you for 1 minute, please.
I have I'm an attorney in Maryland. I support MAJ's position. I have a different perspective. Before I studied law, I was a parole officer in a maximum security prison. And the question is, how many of these people can we keep coming back? Rewarding them when they complete their sentence and their probation or parole to serve in a jury is a carrot that encourages law-abiding behavior once they're out. And that's consistent with the civil justice law, how the law should be for jury selection. I have no other comments, sir. Just a different perspective.
Right. We have more questions. Delegate Arakan, please.
Thank you, Mr. Chair. Thank you all for being here. So some interesting comments, particularly the ones about students at the University of Maryland Law School having to carry the damage of policies that happened 60, 70, 80, 90 years ago. I'm not sure if we're on the same page as that. I mean, that's a lot to try and carry the mistakes of other people that you've never met just because you attended the same law school. Aside from that, the entire concept that this bill is based on, that Black people need to be on juries, we all agree that, but insinuating that it is somehow impossible to find people because we have a higher rate of incarceration for some Black people is a little bit disturbing, and I would say not accurate at all. There are many, many great Marylanders who are people of color who have no criminal history whatsoever and who proudly serve on juries every single day in our state. So it's really a little bit disturbing to hear that for some reason we have to pass this bill or our juries won't have appropriately demographic makeup. It's just not accurate. So I just had to let that out.
Well, thank you, Delegate Arakan, for your comment and sort of question. The best way I could answer that to you is I don't think anyone was trying to offend anyone. I'm a practicing trial attorney. I am in courts across our great state, and there are all shades of Marylanders are part of our system. I think what this bill is, for me, is really anchored in is re-enfranchisement. And the reason why I brought up, and I think other panelists, I can't speak for them, but other panelists brought up the fact that 80% of our inmates in Maryland are African American is because it's specifically impacting that community when you're pulling that jury of peers. It's not anything to say that there aren't African Americans and other folks of color serving on juries. It's more about re-enfranchising the individual, and the individuals back in society, paid their dues to society, and also making sure that no matter what the color of the defendant is, it is a cross-section of their community that is serving on the jury in their particular county for whatever crime it is. So I hope that you could take that into consideration.
Are there further questions for the panel? Seeing none, we thank you all very much. We'll hear now from the people in opposition. I think it's just the one, Joe Riley, State's Attorney, Caroline County. Mr. Riley. He is coming in. One moment, please. All right, Joe Riley, please.
Thank you, Chair Clemenger, Vice Chair Moon, members of the committee. My name is Joe Riley. I'm the State's Attorney for Caroline County and the Legislative Chair of the Maryland States Attorneys Association. We seek an unfavorable report on this House bill. Issues of re-enfranchisement and civic engagement are incredibly important, and they are something that we support. However, they are not what this bill is about. Whenever we have civic engagement and re-enfranchisement bills, we have people from the community who benefit from these bills, and they testify on their behalf. Today, you're hearing from a panel of defense attorneys in support of this bill. So when you're voting on this bill, please consider who this bill is really for. It's not, no one who is on this bill is who would be benefiting from this bill is testifying on it. It's simply a bill for defense attorneys. Thank you.
Okay, have questions for this panel. Delegate Williams, please.
So, Mr. Riley, are you stating that formerly incarcerated individuals are not members of the community in which they live?
No, I'm saying that they're not interested enough in this bill to come and testify on it.
Thank you.
Are there further questions? Delegate McComas.
Just briefly, and whether Delegate Fisher can answer or any of the proponents of the bill or Mr. Riley, who is an opponent. And I'll ask this of Mr. Riley. It's my understanding there are prisoners' rights organizations around the state, and there are a number of organizations, maybe families that have incarcerated people. To your knowledge, or to Delegate Fisher's, or the folks testifying in favor of the bill, anybody familiar with anybody of those different groups that are advocates for this bill? Because I think
I'll address that, Delegate McComas. Thank you. I've had many conversations with groups that we've all seen through this committee, Out for Justice, many who are supportive of the bill. I think my prerogative as the sponsor of the bill, I really wanted to put together a panel. Especially because it's the third time we've heard it. I didn't want to load a panel of, five panels of testimony. I really wanted the legal, and I believe from Mr. Subcommittee Chair, Delegate Cardin, all the kind of conversations we had with this bill for previous years. I really want to hone in on the technical issues, the constitutional issues. So that was just my prerogative as the bill sponsor of what I wanted to highlight. There are tons of organizations that represent these returning citizens that support this bill, and I'll be happy to follow up with the committee with letters of support from those organizations.
Since I was asked, I can say that this is just as this is Delegate Fisher third time putting this bill on. This is at least my second time testifying against it, and I haven't heard from one person who would quote unquote benefit from this legislation testify on it.
And I'm going to step in here because I should have stepped in before. With no offense to Delegate Fisher, who made some good points. We're going to try and stick to the format where we speak to the proponents of the bill, then we'll speak to the opponents of the bill, and we're not going to cross over. We're at the beginning of the year, and sometimes we're out of practice. It's not the end of the world. But
my apologies, Mr. Chair.
No, not at all. Delegate McComas with a question to Mr. Riley, if you have another question.
Okay. So basically, Mr. Riley, bottom line, you don't know of anybody that supports the bill.
No, I know of people who support this bill. Their defense attorneys support this bill. Civic re-engagement issues are incredibly important. Every time we have these types of bills, like people wanting to get their licenses because they have a prior conviction, they have these compelling stories. If I can't get a business started, I can't support my family. You don't have one person in here testify like, I really want to serve on the jury, because there aren't any.
All right. Thank you very much. Am I in trouble, Mr. Chair?
No more than usual. All right.
Okay, good. Then I'm on my game. Thank you.
All right, that's fine. Are there further questions for the panel, for the panel in opposition? Seeing none, thank you all very much. That concludes the testimony for House Bill 74. And we'll go now to Delegate Cardin and House Bill 79. And I'm supposed to call 5 people, so I will do that. Delegate Cardin is going to testify for 2 minutes, then we'll hear from Chad Feisen, Arthur Ebbersberger, Keith Brown, David McCone. There are other people who also wish to testify. They'll be on the second panel. So we'll start first with Delegate Cardin. And he'll go for 2 minutes. Everybody else will go for 1. Delegate
Thank you very
Cardin.
much, Mr. Chair, members of the committee. John Cardin on behalf of House Bill 79. We've heard this bill before. This bill seeks to prohibit indemnity of defense liability agreements. It is a civil issue for those of you who are not involved in civil law. It basically seeks to protect design professionals against specific contractual duties that are against public policy, inappropriate, archaic, and have been outlawed in most other states. This bill basically, in English, it prohibits the ability to put in a contract that a firm has to pay the defense costs or the legal costs of another firm if the firm that's paying the costs has been determined not to be at fault for any damages. So if there are no damages that they created, they shouldn't have to be required to pay for the legal fees for the tortfeasor for the wrong party. The fact is that the state of Maryland oftentimes hires firms and requires these in the contracts, and the vast majority of minority, small, women-owned businesses and other vulnerable companies are incapable of trying to bid for these contracts, these major contracts, to do architectural or surveying work, because they cannot afford to possibly have to pay the legal fees for another company or for the state when they were not the ones that did anything wrong. They actually did everything right. You'll hear from the experts, they'll explain it. And if you have any questions, it's probably appropriate for them to answer them. Thank you.
Thank you very much. We'll go now to 1 minute testimony, and we'll hear from Chad Faison, and I mispronounced your name.
Thank you, Chair, very much. Thank you, Delegate Cardin, and good afternoon, Judiciary Committee. I am Chad Faison, the Executive Director of the American Council of Engineering Companies of Maryland and a proud Prince George County resident. ACC Maryland represents 90+ engineering firms and affiliates, which employs over 7,000 people that live and work throughout Maryland. Of the 90 firms, approximately 30% are MBE, SBE, or WBE. So we do represent the minority businesses. Our members are very concerned about taking on uninsurable risk, which is why House Bill 79 is so important to us. With that, I will relinquish my time to the other. Thank you.
All right, let's go now to Arthur Ebbersberger, please, for a minute.
Thank you, Mr. Chairman. Chairman Keplinger, Vice Chairman Moon, and other members of the Judiciary Committee. I'm Arthur Ebbersberger. I am with CBiz Insurance Benefits. We're a publicly owned company. I have 52 years of experience in the insurance business. We've been fighting this issue for decades. Professional liability insurance does not provide coverage for the defense of other parties than the insured party. Most of you who are attorneys can relate to that pretty quickly under your own professional liability insurance. The policies are written to protect the insureds for their negligence in the event that they do something wrong on the project. They do not provide legal coverage for the negligence of others. And when the duty to defend is in the indemnification clauses, this is an uninsured risk, which means the firms themselves must bear the risk and the potential cost of defending their client. In particular, in this case, let's say it's the state. They would have, that obligation, and they haven't even been shown, as Chad referenced, to be at fault nor negligent in the situation. That puts an enormous burden on these firms, and they cannot afford that exposure, on a go-forward basis. So I wanted to be sure that it was clear. There's no insurance providing coverage for this defense cost, and it would fall to the firms themselves.
Thank you very much. Thank you very much. Keith Brown, please. 1 minute.
Thank you, Mr. Chairman. Again, my name is Keith Brown. I'm with Kim Engineering. We are an MBE multidiscipline engineering firm based out of Prince George's County. My position here is VP of Construction Services, and part of my day-to-day duties is to review and sign contracts. I would say about 95% of the contracts that come across my desk include the duty to defend clause. And this is because it's a flow through from the prime consultant's contract down to the subcontracts. However, unlike the mid to large size firms, small firms don't have the resources to tap into to pay for other parties' attorney fees. And this could cause, in the case of a large claim, the small firms are actually the most vulnerable to a financial strain. And this could cause company layoffs or even bankrupt the company. So if we could pass this bill, this will also help protect the small firms against this clause. Thank you for your time, and I'm happy to answer any questions that I can.
Thank you very much. We'll go now to David McCone, please.
Hi, thanks. My name is Sean McCone, David Sean McCone. I'm the current president of ACC Maryland, Mr. Chair, Vice Chair, members of the committee. I know we have one other person, I think, in the waiting room ready to be admitted, Jonathan Shoemaker, who is a affiliate member of us as well. You have my written testimony, so I'm not going to summarize it. I'd just like to add, I mean, this section of the law and our bill is frequently misunderstood, frankly, difficult to understand and explain at times, but it's very important to us. I think a lot of people's eyes glaze over, and we don't even do it justice sometimes when we try to introduce it to folks. I testified this back in 2015. We had some success in 2017 or in 2016. We reintroduced it in 2020 and tweaked it in 2021, and it hasn't gotten out of committee. I hope we're here today to permanently address that. Year over year, we seem to get letters of opposition, and those letter opposition, then we meet with those people that oppose it, and we clarify it, they understand it, and then the next year they don't oppose it, they've actually supported it in the past. So again, I think there's a lot of misunderstanding when it comes to this bill, what it's really trying to do. It's not trying to relieve us from paying damages if we're found liable. It's trying not to make us an insurance company to pay damages and defend clients up front when there's no negligence that's been found. I know you've gotten a letter from the Office of the Attorney General this year and last year. We met with them over the last session. We're a little disappointed they opposed it again this year. And like I said, nothing in this bill prevents us from indemnifying our clients, making our clients whole, and paying for the defense when we're found liable. And we're open to adding any reasonable statement that would clarify that, although we feel like there's one in on there. So my ask is that you bring this to a favorable vote, set good public policy, despite the continued misunderstandings and maybe recent revised opposition from the OAG. And you should have our response to that in the file as well. So
thank you very much. Thank you.
Thank you.
There are two other people to testify, and you made reference to Mr. Shoemaker. If we want to just bring in Mr. Shoemaker and Mr. Costello, if we could bring them in as well, it might just be easier to go ahead and hear from them right now, and then we'll take questions for everybody. And this is not Haven Shoemaker, mind you, but Jonathan Shoemaker. It's a common mistake. Mr. Shoemaker, Jonathan Shoemaker is coming in, and we'll hear from him, and then we'll give him his minute to speak. And then we'll
Chairman, I'm here if you can hear me.
That's fine. Let's hear from you. We'll give you your minute, and then we'll take some questions. Go ahead.
Thank you, Mr. Chairman, and good afternoon, everyone. My name is Jonathan Shoemaker, and I'm on the front lines of the issues presented in this bill, as our law firm represents design firms in both corporate and litigation matters. When a claim is asserted implicating a design professional's services, the claim will either be meritorious or non-meritorious. This bill protects design professionals from exposure to liability until such time as there's been a determination of the design professional's fault. Design professionals are not in the insurance business, but when contracts include a duty to defend, the law treats design professionals as an insurance carrier for their client. Unfortunately, unlike other businesses, and you've heard from Mr. Ebbersberger, design firms do not have the ability to allocate these risks to others as to an insurance carrier themselves. The only way to manage these risks is to pass them along to a subconsultant who, as you've heard from Mr. Brown, are then forced to absorb these unfair risks themselves. This bill holds design professionals fully responsible for the consequences of their conduct, but protects them from being treated like an insurance carrier instead of the design firms that they are. Thank you.
Thank you very much. Now my phone is fighting with me. Stop it. All right, great. Does any members of the committee have questions for the panel? I see Delegate McComas and then Delegate Shoemaker. So Delegate McComas to begin.
Yes, Mr. Shoemaker, quick question. Bottom line is, do other states require different professionals to indemnify down the line like Maryland does right now? Require them to duty to defend?
So it's a mixed bag in terms of across the country. I don't practice in every state, but I can tell you that in Virginia, just in 2020, they enacted similar legislation. I believe it was in 2019 that North Carolina enacted similar legislation, and the prohibition on duties to defend do not prevent claims from being pursued against design professionals. I also practice in Virginia, and I can tell you that the absence of duty to defend and doesn't stop them from, in fact, pursuing claims or from design professionals accepting and assuming responsibility when they're liable for something. It's just they're not paying attorney's fees for other people's before there's a determination of fault.
Well, the thing that I'm kind of concerned about is I think, we want small business. Small business is good for communities, for the economy, for people to find jobs that they're not, a little speck in the corporate cog. So the question I have is, we really would be doing a service by passing this, if you think so, or Mr. McCone, if we pass this for small businesses.
Well,
small business.
I think that that's actually absolutely correct, not just for small businesses, but for the state as well, because when you have, you're going to be doing a service for the small businesses who lack the bargaining power, where they either have to accept contracts or not, and especially for the MBEs, the CBEs in Maryland, who are more frequently sub-consultants than prime consultants. They're forced with a decision to either accept the flow through of the terms of the prime agreement or to pass on doing the work. And oftentimes where the strongest incentives are on public contracts, it depends what the terms of the prime contract are. And the only way that they can really leverage the benefits that the legislature has enacted is to really participate on those public contracts, whatever those terms are. So it really would protect those small businesses and provide a leg up. We represent both big businesses and small businesses. I can tell you the smaller businesses spend far less money with lawyers because they just don't have the resources to fully appreciate and understand these risks. And so this type of legislation is really to protect the smaller businesses, because the large firms can make their decisions and they can pass the risk down along to the smaller firms, but the small firms don't have that same ability.
So if I could just paraphrase to make sure I'm clear on this, this would help minority-owned businesses, being folks of color, as well as women, as well as if a disabled person, in other words, this would different classes of folks that we are concerned about making them independent and economically viable, and providing good living for themselves as well as their employees.
Absolutely, and that's an issue we discussed with the OAG this summer when we met with Attorney General Frosch, and it's an issue that I would note was not addressed in their opposition letter as to why their opposition, how it's consistent with the policies that have been established by the legislature.
Thank you, sir. Thank you, Mr. Chair.
Thank you very much, Delegate Shoemaker.
Yeah, Mr. Shoemaker, that's a great name, by the way. I want to commend you for that right from the get-go. You drafted a response addressing the Office of the Attorney General's concerns that are in our packet, I believe. And I was wondering if I could get you to elaborate a little bit on a couple of those items that you mentioned in response. I mean, could you speak to the issue that the Attorney General raised regarding risk shifting? Could you allude to that a little bit?
Sure. So when a claim is pursued against the state implicating the services of an architect or an engineer, the claim is going to either, as I said during my opening testimony, will be meritorious or non-meritorious. If the claim against the state is non-meritorious, then there's no reason that the state should have any interest in seeking to be compensated by a design firm. And so all this bill does is not prohibit the shifting of risk, but to delay the shifting of risk until such time as there's a determination of fault.
Okay.
So I would disagree with the suggestion that it shifts risks in any way. It just deals with the timing of when the risk is established and shifted.
How about their concern regarding this bill's limiting the state's ability to seek indemnification?
Well, I quite frankly, because I have the opportunity to not just negotiate the clauses, but also litigate them, have never seen any limit as a result of the indemnity provision. Anytime that there's a claim that is being pursued against a design professional, the state can pursue a simple, plain vanilla breach of contract action. There's no requirement for an indemnity clause in order to do that. Or two, they pursue a claim for indemnity. And the statute itself that's been proposed says that design professionals should be fully responsible for indemnifying for liability to the extent of their fault. And so if the design professional is responsible for damages, the statute expressly permits the recovery of those damages. And so really the only type of damages that would not be recoverable would be if there were, using sort of round numbers, $100,000 of damages, $70,000 were found to be the fault of the design professional. Well, the state would be able to recover $70,000 and not $100,000. I don't really understand why the state would be interested in collecting $30,000 from a Maryland business that wasn't due to the fault of that Maryland business. And so it doesn't really make sense to me. The ability for them to recover is there. And I would also note, because I have the opportunity to actually interact with the insurance carriers, when we're talking about these types of issues on the indemnity front, it also tends to implicate coverage issues. And if anybody's ever submitted an insurance claim, you probably know how frustrating it can be to deal with an insurance carrier who is questioning coverage, whether or not, instead of focusing on liability. And so the presence of a coverage issue can actually be an impediment to resolution of claims. And so the type of, so clear language like this, which says you can be liable only to the extent of your fault, that's squarely in line with the policies, and it removes the insurance coverage issue from the conversation. And so I've seen that be an actual assistance in resolving issues as well.
Are there further questions for the panel? Seeing none, we thank you all very much for being here and for your testimony today, and that'll conclude the testimony on House Bill 79. We're now down to our final bill. And this bill is Delegate Rosenberg's bill, and he is here, we hope.
Yes, sirree.
All right, excellent. So we're going to hear from you, from John Breen, from Jim McLaughlin, from Rebecca Snyder, and from Ron Jericho. We'll hear from that entire panel, then and then we'll have questions, and then we'll have the opponents. Delegate Rosenberg's going to have 2 minutes. Everybody else will get one. But Delegate Rosenberg for 2 minutes, please.
Thank you, Mr. Chairman. This committee knows this bill well, knows the issue well of SLAPP suits, as you have passed this bill out last year, and I believe the year before as well. SLAPP suits are strategic lawsuits against public participation. They are brought to intimidate people who, the little guy or gal who participates in the public process, who testifies before a public body or writes a letter to the newspaper or does something online in opposition to a proposal, say a zoning proposal or development proposal, most often. And the process that in response that the community people, the individual has to go through is intimidating. Most recently, the case before the Court of Special Appeals, a $25 million damage claim when the damages were nowhere near that amount. What this bill would do, the two principal things it would do are remove the requirement to demonstrate bad faith. The whole purpose of the SLAPP is to have an expeditious resolution of the case, to get it to defeat its purpose of intimidating the community member, our constituents. So to have to prove bad faith is, as the judge recognized, Judge Harrell recognized, does not need to be a part of this process. The bill would also broaden the nature of the public participation that would be covered by the bill. I would just conclude by saying, as was the case last year, concerns have been expressed about the impact that this bill would have from the pro-life community. We addressed that issue last year. It is not a valid concern, and we can make available to the committee the response that we got last year from the Attorney General's office to that effect. And if there are questions regarding that, I believe Mr. McLaughlin is well prepared to address them. Once again, a favorable report. Thank you.
Thank you. We're going to go to Mr. McLaughlin first. Mr. Breen is not in the Zoom room, so we'll go to Jim McLaughlin now.
Thank you, Mr. Chairman and committee members. I'm Jim McLaughlin. I'm an in-house lawyer at the Washington Post and a board member of the Maryland, Delaware, DC Press Association. You have my written testimony, and I know that for many of you, you've heard me advocate for this bill or prior versions of it in years past, so I won't belabor what I've said in my written testimony, although I'm happy to answer any questions. I would say that, as Delegate Rosenberg mentioned, it's important to understand that anti-SLAPP bills are not partisan or ideological in nature. And so specifically with respect to the objection raised by the Maryland Right to Life movement, I would say speech about abortion, for instance, would be protected by SLAPP statutes, regardless of whether it's of which side of a controversial issue it's on. And there are actually lots of examples in practice in which speech by conservative outlets has been protected by anti-SLAPP statutes. The key inquiry in a SLAPP situation is whether the litigation is an attempt to deter and chill speech, and whether that speech is on a matter of public concern, which speech about something like abortion clearly would be. And so we, as Delegate Rosenberg said, we don't believe there's actually merit to that criticism, and the Maryland Office of Attorney General last year took a similar view of it. But I'd be happy to address that concern in more detail and any other questions about the bill, which the Post and Press Association certainly support.
Thank you very much. We'll go to Rebecca Snyder, please.
Good afternoon, committee. I am Rebecca Snyder with the Maryland, Delaware, DC Press Association. We're pleased to support House Bill 70, which, as Jim and Delegate Rosenberg mentioned, would strengthen Maryland's anti-SLAPP law. We do feel like this legislation respects and maintains the balance of citizens' free speech while avoiding overly punitive measures. And will not deter the filing of valid lawsuits, and will ensure that every deserving party gets their day in court. So this legislation was passed by this committee in the House last session. SLAPPs are not just an issue for the news media. They stifle public debate and diminish civic engagement for private citizens seeking to make their voices heard. They also present, not only do they present a financial and sort of emotional burden for individuals, but they also burden news media. They are both financially strapping because of obvious legal costs, and also because responding to often frivolous challenges can be a time-consuming distraction. So those burdens diminish our members' ability to cover the communities they serve. Any journalistic organization that does its job will occasionally discomfort people with their reporting. And when there's harm and real cause for action, there should be recourse. And we don't believe this bill would change that balance. We support the proposed changes and believe that they're an important rebalancing that makes it harder to silence journalism and the public. So we urge a favorable report, and I'm happy to take questions.
Right, let's go to, we're going to go backwards now to John Breen, who is in the room, I believe, and then Judge Jericho. John Breen. Maybe not. There he is. Maybe. Mr. Breen. You're going to need to unmute yourself, Mr. Breen. All right. There he is.
Sir, pardon me. I'll
Go
be
ahead.
brief. Thank you for your patience. I'm a member of MAJ, and I'll support the statements made by Ron Jericho. I would just emphasize that the purpose of the SLAPP suit is to allow prompt action on a motion to dismiss. And if that claim, SLAPP suit claim, is found to be without merit, it allows the prompt termination of an award of attorney's fees against the burning filing. That protects free speech in the community. I have no other statement.
All right. Thank you very much. We'll now go to Ron Jericho.
Thank you, Mr. Chairman. My name is Ron Jericho. I'm testifying on behalf of the Maryland Association for Justice. As you've heard before, I'm a former circuit court judge. This law brings the Maryland law and updates it to be consistent with state laws across the country. We've submitted a written paper in support of this, and in there got a citation to a state anti-SLAPP law study that shows all the jurisdictions that have adopted a modernized law. And so this will bring Maryland into consistency with the other states. And that's important because it protects free speech. It protects the expressions of in the public interest. And I was involved in defending a SLAPP lawsuit back in DC about 2 years ago, where it was criticism of a public official. If you need other examples, you could do I did a quick Google search on Trump and SLAPP suits, and there are multiple examples of suits against CNN, defamation, Apprentice, when he was with the Apprentice group and criticism there in that program. In any event, these are all intended to protect the rights of citizens to give public criticism of either public officials or other reasons. And I'll just comment on one area. You'll see a section talking about mandatory attorney's fees awards for frivolous lawsuits. Then if you look at the study that was done, I think it was submitted as an attachment to our paper, just about every state has mandatory attorney's fees if there's a frivolous lawsuit that was intended to suppress public commentary, public outreach. And so it's a very valuable law, a very valuable right. And to update the Maryland law is overdue. And with that, the Maryland Association requests a favorable report on this bill.
Thank you very much. Are there questions for this set of witnesses? Delegate McComas.
Go ahead. Okay. I'm from Harford County, and I know of some situations where they've been used as far as with development issues, and then neighbors might have been concerned about it, and they got hit with SLAPP suits. And you can't, from what my understanding, you can't get insurance for a SLAPP suit. And they were all concerned about losing their homes. Anyway, it was rather not a pretty picture. So I'm just kind of like wondering if the SLAPP suits are mainly, if anybody has categorized the different type of SLAPP suits, and if a large portion involve development and communities that are kind of fighting the development, because that's, it's really local issues, and people want their community to be, what do I want to say, homogeneous, as far as they don't want a shopping center right in the middle of their neighborhood necessarily. So I wondered if there's more SLAPP suits regarding development and not in my backyard kind of things, as opposed to other types of SLAPP suits, or are there other types?
Community response to a development proposal is often the basis of a SLAPP suit in response. I would think within the last year or two, there was also, coincidentally, in the 46th district, there was a SLAPP suit in response to a community objection on a liquor license issue, similar to a development issue. So that, I think, that is the genesis of the SLAPP suit, my best knowledge, but it has been broadened to include also SLAPP suits being brought against various publications. And that's why the Maryland, DC, Delaware Press Association and the Post are before us today, and as well as the Maryland Association for Justice.
What I would like to know is what other kinds of SLAPP suits are out there, because I've seen where people are concerned about a SLAPP suit being used to, thwart political speech, let's say conservative or liberal speech, or maybe certain, like the issue of abortion, things like that. Are those realistic worries?
If
I may.
Sure. Yes, Delegate McComas, those are realistic worries. And I would say there are, broadly speaking, at least 3 different kinds of SLAPP suits that I see as a practitioner in this area. One is the developer and local citizen category that you talked about, which is sort of the prototypical SLAPP. Another is increasingly the use of defamation suits to go after the press over sometimes very trivial disagreements with coverage, often by deep-pocketed plaintiffs, Russian oligarchs, wealthy celebrities or public figures, and so forth. And then that is becoming a huge problem. That's definitely on the rise in the past 5 to 10 years or so. And then the other area where it comes up often is consumer reviews. So like Yelp has been hit with a number of SLAPP suits. Ratings, Angie's List had one in DC years ago. So where businesses or plaintiffs, individual plaintiffs sometimes try to go after people who post negative reviews of their services online and basically say, I'm going to sue you for defamation over this review unless you take your review down. And there's clearly a public interest in those people not feeling bullied into taking their review down because they don't want to spend thousands of dollars defending a lawsuit. So those are sort of, broadly speaking, 3 of the main areas of SLAPP litigation.
And if I could add to that, MCASA has testified in the past on this bill because sometimes SLAPPs are used to silence victims of or survivors of sexual violence and domestic violence. And I don't know if they've submitted testimony on this in the past. And then also in the past, this bill has come up several times. The water keepers have submitted testimony specifically that some of their water keepers have been threatened with SLAPP suits on environmental issues. So it is pretty pervasive as a problem.
If I could further answer that question, last year or 2 years ago, I was defending a SLAPP suit that was just a criticism of a public official in Washington, DC. And that was nobody in particular, not a political character. And that was a lawsuit that the person filed. And if you do some search, some Google search, you'll see that CNN had a SLAPP suit filed against it for its public criticism, consistent with what Ms. Snyder and Mr. McLaughlin has said. So those appear to be the kinds of categories.
All right, thank you for that. We're going to hear now questions from Delegate Cardin and Delegate Arakan. Thank you.
Thank you, Mr. Chair. Just want to find out if is this bill in the same posture it was when it passed out last year?
Yes, it is.
Thank you.
Delegate Arakan.
Thank you, Mr. Chair. Thank you all for being here again. I'm very interested to hear a little bit more about the SLAPP suits or alleged SLAPP suits for Yelp and for the reviews. I mean, the insinuation, I think, from the testimony we've heard today is that those suits are totally without merit. But I have personal knowledge that many times companies will hire people to write fake reviews for products. Very intimate knowledge of it. So how would we know if that's what occurred if the suit gets thrown out?
And if I can take that, looking at what Yelp had, some of their testimony from the past, I think what would happen in that situation is that it will always go to a judge who will then either order targeted discovery or order discovery in the case or not. And so there's an opportunity for there to be discovery in that case, which would theoretically weed out, kind of those review mill kind of situations.
And then how is that not occurring already today? How is a judge not able to weed out these cases already today by doing discovery?
They may be able to, but the fact of discovery alone is, extremely expensive. And, what SLAPP statutes do is provide an expedited mechanism to get to the resolution of a case without having to incur hundreds of thousands of dollars in legal fees. And under this bill, the possibility of fee shifting at the end, not just the possibility, but the presumption of it is important, because the company that it is bringing a suit intended to bully somebody is less likely to do that if they think at the end of the day, if we lose this lawsuit, we're actually going to have to reimburse their legal fees, than if they don't have that prospect, and then they know that the person will probably just fold their tent rather than incur the expense of litigating the claim.
So today, a judge is not capable at the end of the case of assigning the cost of the discovery, the expense of the discovery, if the party's found to be not guilty of this. The judge cannot force the other party to incur those expenses currently?
Typically, they can't. The presumption is each party bears its own fees, and there are some exceptions to that in cases of extreme bad faith and vexatious litigation and so forth. Judge Jerishow, I'm sure, is familiar with those exceptions, but it requires it's a departure from the normal practice. Usually, even for a frivolous lawsuit, both sides are just on their own for expenses.
Okay, thank you very much.
Let me just add that's right. Absent a statutory right, you don't recover your attorney's fees. And the important aspect of this law, as Delegate Rosenberg pointed out, is that you get expeditious resolution of whether it's a frivolous lawsuit or not. And that means that you can avoid the expense of litigation and the discovery, which is overbearing for some people, especially when you've got a large institution be suing an individual. And it would have to carry that burden. So the bottom line is that this is a law that helps protect free speech.
Thank you all very much. Thank you for answers to the questions. We're going to go now to those in opposition to the bill. And we're going to hear from two people. Let me get my list, which has gone away. There it is. All right, we're going to hear from Laura Bogley. We're going to hear from James Walton, who are going to testify. I think they are both in the room, so we'll hear first with a minute of testimony from Ms. Bogley.
Thank you, Chairman Clippinger and members of this committee. I'm Laura Bogley, Legislative Director for Maryland Right to Life. On behalf of our members across the state of Maryland, we respectfully ask for your unfavorable report on HB 70. In its wisdom, this assembly passed the original anti-SLAPP statute to avoid frivolous lawsuits and to protect the freedom of speech for all of Maryland's citizens. But the bill before you today asks you to use your authority to weaponize the courts against certain speech and speakers using a new subjective judgment standard. When your esteemed predecessors enacted the Maryland Act of Toleration in 1649, to protect religious freedoms for all Christians, they understood that the right to freedom of speech was necessary, not when people agree, but when people disagree, and particularly when they disagree with the government. Yet here we are again this year because a Catholic high school student attending the National March for Life was awarded legal settlements against two national media outlets who defamed him and falsely accused him of hate speech because they disagreed with the boy's deeply held religious, political beliefs. This bill is a slap in the face of justice, and we urge you to vote no. Thank you.
Thank you very much. Go now to Mr. Walton. James Walton, please.
Hi there. Can you hear me?
Yes.
There we
Go right
go.
ahead for a minute.
Okay. Thank you, Mr. Chairman and members of the Judiciary Committee. My name is Dr. Jay Walton, and I'm the leader of 40 Days for Life here in Lutherville, Timonium, Maryland. I'm here to testify against this proposed version of the SLAPP law, HB 70. Indeed, the current law is good just the way it is. As someone who prays in public, the current SLAPP law protects me from frivolous lawsuits and upholds my First Amendment right to freedom of speech. For example, imagine that your child is praying outside. Someone gets offended by your child praying and goes to the local newspaper and says that your child is a white supremacist. Under the current version of the bill, you could sue the newspaper for libel and slander and simply say, look, these accusations against my child are false. The newspaper didn't like my child praying, so they slandered my child's good name, and we demand some relief. Under the proposed legislation, this bill would weaken the original statute and create a huge legal loophole for news outlets and other actors to evade legal liability for acts of libel and slander. This bill is an attempt to suppress pro-life speech and scare people into silence. It is bad public policy. I respectfully urge you to protect our First Amendment rights by rejecting House Bill 70 and its broad expansion of SLAPP suits.
Are there questions for this panel? Any questions for this panel? Delegate Cox?
Thank you, Mr. Chair, and good to see you, Laura and Dr. Walton. Thanks for being here today. I'm assuming you heard the testimony a minute ago from the Washington Post Counsel. Were you able to hear that when you were in the?
Yes.
Okay, so they claimed that this bill was to protect the little guy. Do you see any little newspapers here testifying today other than the Jeff Bezos biggest newspaper really in the world?
Nope, you're right.
Okay, that's all.
Yeah.
Thank you.
To answer your question, Delegate Cox, I know last year when this bill came before the committee, there was some discussion about how this only applies to commercial actors. And we heard them referencing some big corporate actors. But there's nothing in the statute that says that. There's an optional or in the paragraph rather than and commercial speech as part of the requirement for denying this affirmative legal offense. So this absolutely can be used against individuals, against nonprofit organizations who certainly couldn't go up against a mega corporation like one of these major national news outlets.
And this is coming on the heels of what is it, an $800 million settlement or so from the Washington Post. Am I correct in that?
Well, it's supposedly an undisclosed amount, but I've heard that it was substantial and rightly so.
Thank you.
Delegate McComas?
Okay, I know it's my second bite at the apple. Hopefully it won't be a rotten apple. Is there a chance that I am concerned about the folks that were harmed by the SLAPP suit because they voiced their concerns about a development, and it did have a chilling effect of free speech because it was right during the time of Harford County's comprehensive rezoning plan. And so I am kind of concerned that for that. I also respect you all's concern about the little guy. So I'm wondering, is there some common ground that you and you, Laura Bogley, as well as Dr. Walton, can work with Delegate Rosenberg to craft something that takes care of the SLAPP suit for folks that are just trying to, exercise their freedom of rights as far as government action, a development, because that's where I'm concerned. And that's why I know I had talked to Delegate Rosenberg about this in the past, because I just think that, these folks were just doing what they thought was best for their community. And then they got hit with the big suit. So, and I mean, they had fear they were going to lose their house. So anyway, I'm just hoping that there's some common ground here and that we can protect you and we can help the folks that have, as far as speaking up in public about certain public issues. So
Delegate McComas, I'm very happy to work with the sponsor of this bill, but I think the Maryland General Assembly and this chamber did an excellent job of crafting the original statute. And as many of the speakers here, including Rebecca Snyder, attested, there's already a process in place under the current statute for the judge to provide that preliminary review to even determine whether a defendant is eligible or would qualify for the SLAPP suit affirmative defense. So that process is already in place. It's already available to judges and courts in the state of Maryland, and it's not broke, so there's no need to fix it.
Are there further questions for this panel? Seeing none, we thank you both very much for testifying here today. And that'll conclude the testimony on House Bill 70. That also concludes the testimony for today here in the Judiciary Committee. Tomorrow, if I'm not wrong, I believe we have a briefing at 1 o'clock with Health and Government Operations and Senate Finance and the Judicial Proceedings Committee. It's going to be quite a thing, where we talk about hospital liability. That's going to begin at 1 o'clock, and that is when we will be back on the air. So thank you all very much for your time today, and have a good evening. Thank you.